Is that working okay?
Yeah, that looks great. Um, Welcome everyone. My name's Anna. I'm one of the program coordinators at the Lawyers Committee for Civil Rights, the Legal Services for Entrepreneurs program. Today we're going to have a presentation for our immigrant business series on the American with Disabilities Act and having your business being compliant with ADA. If you need interpretation, please go ahead and access interpretation right in the symbols at the bottom of the Zoom screen. It's right next to the raise hand symbol. It looks like a world, and you can just access it there. Bienvenidos a todos, mi nombre es Ana, soy una de las coordinadoras del programa de servicios legales para empresarios. Hoy vamos a tener una presentación sobre la Acta de Disabilidades de los Americanos y vamos a tener esta presentación que es parte de la serie para los negocios de inmigrantes. Si necesita interpretación, si puede hacerle clic al mundo que está el símbolo del mundo que está a la mano derecha del símbolo de la mano, ahí puede accesar a la interpretación. Si tienen preguntas, por favor, mándenlas por chat. If you have any questions, feel free to send them through the chat or the Q&A box. We'll go ahead and get started now and welcome our presenter, Stuart, and he'll let you all know a little bit about himself.
Hi, everyone. Thanks for attending. Thanks for letting me talk with you. I'm an attorney. I've been an attorney for many years now, since about 2011. I've lived in the Bay Area for a long time in Oakland and Berkeley, and I work out of our San Francisco law firm office. My real area of focus is the Americans with Disabilities Act and related laws. I represent businesses and businesses and landlords. I don't represent the people that sue those businesses, so I'm just on the business side. I have a background in technology, including computer programming and website accessibility. I was at Berkeley for undergrad and Harvard for law school. So we're talking about the Americans with Disabilities Act today. It's something that I think every business really needs to know about and think about. Otherwise, that there are plaintiffs that will bring lawsuits over this issue, and so that's something we want to try to avoid if possible. It's an important issue because I like to say that we all either need accessibility issues right now, or we're one accident away from needing ADA issues. The ADA, it was signed into law in 1990, and here's a picture of George H.W. Bush signing it into law. There are 5 parts to the ADA. Title III, that's the one that really concerns you as a business owner. That's the area that deals with ADA compliances for what's called public accommodations, but it can basically means businesses. So that's the area that relates to you as an employer and how you serve the public. So this is the basic rule under the ADA. It states that all places of a public accommodation, essentially every business, needs to provide full and equal access to the goods, services, privileges, and facilities. So you basically need to provide equal access for people with disabilities, and that relates to parking lots, entrances, elevators, counters, restrooms, certainly. So the way that the law was written originally is They didn't want to have another government agency enforcing the law. It was passed under a more conservative administration. So rather than have another agency enforce the law, they decided to allow individuals to enforce the law by bringing lawsuits when there's a violation. So there have been many lawsuits filed under the ADA after it was passed, and there are plaintiffs that go around basically looking for this type of lawsuit. There are roughly 10,000 ADA lawsuits filed in U.S. Federal court each year, and then there are a lot of cases also filed in state court. California is really one of the areas where we see the most lawsuits filed. There are California state laws that provide a further incentive for plaintiffs to bring these lawsuits. And the plaintiffs, by the way, are generally the people with disabilities that file the lawsuits against the businesses. So the plaintiff is the person that brings the lawsuit, and the business is generally the defendant. So here we see a breakdown of federal ADA lawsuits by state. You can see New York and California have a lot of these lawsuits. And here we see an increase in ADA lawsuits over time. This only measures the federal litigation. It's much harder to track the California lawsuits because they're filed in individual counties. So this is just looking at the federal litigation. As you can see, in 2022, there was a real move from federal courts to state courts in California. And that's because the federal courts became less friendly to these types of lawsuits. A lot of judges were cracking down on them and trying to eliminate them. But the plaintiffs just moved from federal court to state court. So here's a similar graph. We can see the blue is California. So the blue at the top here is California lawsuits. And so there's a big drop in the federal lawsuits in California in 2022. But the real number is probably closer to this 6,700 when you consider the state court lawsuits as well. So a lot of those cases move to state court. So what happens when your business is sued for ADA compliance? The plaintiff who files the lawsuit is looking for three things in California. The first is injunctive relief. Whoops, let me go back. The first is injunctive relief. That's a court order to improve the property and make it accessible. If we're talking about the store, there might be a ramp or parking that needs to be updated. If it's a website case, which we'll get to, then they'll be suing to have improvements made to the website. The second thing they sue for is attorney's fees. So the plaintiff is going to sue for the costs of their attorneys to bring the lawsuit. And then the third thing in California is they can sue for statutory damages, which is a monetary payment. It's a payment of about $4,000 per visit to the property. And so, you know, they'll often allege 1 or 2 visits. There is a duty to mitigate your damages, to not just keep adding up your damages in California. And so they can't easily allege, you know, 10, 12, 15 visits because there's a duty to limit their damages. But they will often sue for statutory damages of, you know, 2 or maybe 3 visits. So that's 4,000 times 2 or 3 on top of their attorney's fees and their claims for injunctive relief. So that's what you're looking at when you get an ADA lawsuit. So we'll look at what is the basis for a lawsuit under Title III of the ADA. And it has three elements to it. The first is that the plaintiff has a qualifying disability, and we'll get into what that means. The second is that the establishment is a place of a public accommodation, basically a business open to the public. And the third is that the plaintiff was denied full or equal treatment because of the disability. So going a little bit deeper into each of those, the first one here, that the plaintiff has a qualifying disability, that basically means any physical or mental impairment that substantially limits one or more major life activities. And so we're talking about we're talking about everything from being in a wheelchair, using a walker, being blind, even learning disorders can qualify, hearing impairments, drug addiction. It does actually qualify when someone's not currently under the use of illegal drugs. So we'll look at the second element here for an ADA case, and that's that the place is a public accommodation. And there are lists of different types of businesses covered here. We're talking about restaurants, stores, cafes, theaters, gyms, pretty much any business that's open to the public. The third is that the plaintiff encountered an ADA violation that denied them equal treatment because of the disability. And the key there is that it has to relate to the person's disability. So if someone's in a wheelchair, they can't sue for issues that relate to blind people, for example, and vice versa. So who can be sued for an ADA violation? Is it the landlord or the tenant? The answer is both. It's really either one, and plaintiffs will frequently bring a lawsuit against both the landlord and the tenant for physical accessibility issues. And so there's what's called joint and several liability under the law. That means that a plaintiff can go after either the landlord or the tenant or both for the full amount. So they can sue just the landlord, they can sue just the tenant, or they can sue both of them together. The landlord and the tenant can determine who's responsible between themselves under the lease agreement. So the lease agreement can say that the landlord is responsible for all of the exterior, the outside of the building, for example, the parking and paths of travel, and the tenant's responsible for only the interior. That doesn't stop the plaintiff from suing both of them, but it means that that the landlord would have to take care of and indemnify the tenant for everything outside, for example. And so the landlord might have to pay the tenant for its legal fees if that's what the lease shows. So on that point, it's very important to make sure you have good lease language that addresses this issue. I've read dozens and dozens of different lease agreements, and so I'm happy to help you with that if you need some help taking a look at your lease or renegotiating a lease. Here are a couple of basics about the ADA. So I get this question a lot. Does the ADA apply to buildings built before the ADA was signed into law in 1990? The answer is yes. Every building that's being used by a business open to the public does have a duty to make it accessible. I will say there's a lower standard for buildings built before the ADA. It's called the readily achievable standard. It means that the landlord and the business have a duty to make it accessible to the extent that it's easily accomplishable and able to be done without much difficulty or expense. If it's a newer building, then there's a higher standard for compliance with the law, but the building does need to be accessible either way. Here are some of the frequent areas of litigation. These are some of the issues that we see come up in these cases. Parking lots is probably the biggest by far. That's the thing we see the most. It's the first thing someone encounters when they get to a property, if there is parking, that is. It's easy for parking to sort of deteriorate over time and to not maintain a status that's compliant with the code. Entryways and restrooms are probably the two other big areas that we see a lot in these ADA cases. So just to be mindful of that. Here's some urban legends, some myths about the ADA that I hear people ask about. The first is that the building's constructed before the ADA, so you're exempt. Like we said, no, that's not the case. The second is that a licensed architect or general contractor designed and built the building, so it must be correct. That's also not the case. We often see them get it wrong. And even if there was a certificate of occupancy issued by the building department, it still doesn't mean that it is ADA compliant. The burden is really on the business owner and the landlord to make sure that you're compliant. Okay, moving on here to ADA urban legends. Here's some more myths that we hear about. First is that just because you're the business operator doesn't mean that you're responsible. Like we talked about, no, even the business operator can be held responsible. First is that, the next one is that the building, it's separately managed, so you're not responsible for ADA violations. That's not the case. Sometimes with hotels, for example, there's the hotel owner, and then there's the hotel operator, the manager. And those are two different companies. Both can be held responsible under the ADA. And the last one here, that you can refuse service to anyone. You cannot refuse service to someone because of a disability. And that's the same thing because due to race or gender and other protected classes. So, if they don't have enough money, that's one thing, but if they have a disability and you're refusing to serve them because they have a disability, that's a violation of law. So here are some defenses to ADA claims. The first one and the best one is that the property is compliant, that it's up to code, and there's no violation of law. The second is that there's been a mitigation of damages. So like I talked about before, the plaintiff has a duty not to just rack up damages and keep coming to the property and keep incurring difficulty and damages there. They need to limit it and try to fix the issue first. Next is that there's a bona fide interest in the goods or services. So the plaintiff needs to have a real, a genuine, bona fide here just means a genuine, a real interest in actually using the goods or services of the business. They can't be going there with no real intent to do business. So these are some of the defenses that we use to help businesses and defend them in these types of cases. One thing I will say is that when the plaintiff brings a lawsuit against your business and the lawsuit lacks any merit, it's just, a BS lawsuit, there's no real validity to it, then it's possible to receive an award of your attorney's fees from the court. So any amount that you have had to spend in the case can be returned and paid back to you by the plaintiff. And I recently won 2 awards of attorney's fees for my clients. So the plaintiff had to pay the business because the case lacked merit, and the court sided with us. Here are some of the key issues to think about for accessibility. Here's an outline of what accessible parking will look like. There's this striped access aisle in the middle, and there should be proper striping. There should be proper signage for the parking. There should be the correct dimensions, and the whole thing should be flat and level. It needs to be 2.1% or less in slope. So this is an example of bad parking. This is what you don't want to see. If your parking looks something like this, then it's probably an ADA violation and a lawsuit waiting to happen. This is an example of what looks like good accessible parking. It's flat. The asphalt is not cracked or warped. There's the right striping and signage. You've got this access aisle here. You've got the accessible parking sign at the top. So this is what we want to see, and not that. Similarly, sales and transaction counters, they should be 36 inches maximum above the ground. This is an example of what you don't want to see. This is a bad transaction counter because there's no lowered portion. So someone in a wheelchair is going to have to try to reach up above their shoulders to do business. This is instead what you do want to see. So this is good. There's a lowered portion here for someone in a wheelchair. Restrooms are very complicated. There are all kinds of specific rules and regulations for where the toilet needs to be, how far from the wall, where the grab bars need to be located. And, when I was going to Berkeley, I never thought that I would be out in restrooms measuring toilets, but, sometimes that's what the job requires. Moving on here to service animals. This is a funny picture, but it actually, kind of lends a little insight into the ADA here. Miniature horses can actually be service animals under the ADA. They tend to live longer than dogs, and some people are allergic to dogs, but not allergic to horses. So there's a difference under the law between service animal and an emotional support animal or a comfort animal. So the one on the top right here, that's a service animal, and the definition is any dog or miniature horse that is individually trained to do work or perform tasks for someone with a disability. And that's different from an emotional support animal that's not individually trained to help someone with a disability. It's basically just, a comfort animal, an animal that helps you feel better. It doesn't have any real training to do any specific tasks. And so the tricky part, though, is that, let me go back here. The tricky part is that there's really no good certification that exists for service animals versus emotional support animals. there's no government agency that issues a certificate for service animals. It really just comes down to, is the animal trained to perform work for someone with a disability? So service animals are protected by the ADA, and they need to be allowed in your business. So if someone has a service animal, they do need to be allowed to enter the business, even if it's a restaurant. An emotional support animal is not covered under the ADA, so they're not required to be protected by the ADA. And so emotional support animals you can turn away, but it's tricky and it's problematic to make that distinction, to tell what's a service animal, what's an emotional support animal. So you do need to be cautious there. By the way, emotional support animals are protected under the Fair Housing Act. So if we're talking about apartment buildings, then emotional support animals are protected and need to be allowed, but we'll put that aside. Businesses can only ask 2 questions about service animals. So the first is the animal required because of a disability? And the second is, what work or task has the animal been trained to perform? So those are the only 2 questions you're supposed to ask. So you're not supposed to, ask them for proof of being a service animal, or ask about their disability and medical condition. So just keep that in mind. So a service animal is not required to wear a special vest or a harness. A lot of people think that that's what makes them a service animal, but they're not required to wear anything like that. There's no special certification required. And a service animal, yes, it can accompany someone to a restaurant, like a salad bar even. If we're talking about hotels, hotels cannot charge extra for service animals, but the business owner is responsible for the care of the service animal and can be held responsible for any damage the service animal creates. Here are some of the limitations on service animals. So you can turn away a service animal if it creates a direct threat to the health or safety of individuals. So they're, for example, you can turn away a service animal that's barking and snarling or trying to bite at people. That's a safety issue. You can also turn away a service animal if it is creating a fundamental alteration to the business. So, for example, a dog barking in the movie theater, that disrupts the whole movie, it disrupts the whole experience for everyone. And so it undermines the actual functioning of the business. So you can turn a service animal away for that. We got a bit more time here, so I'm going to talk about a really important issue that we see coming up quite a bit now. This is website accessibility. So any business with a website really needs to think about this. When I first started practicing in this area of law, we just did not see website ADA cases filed really at all. There were a few on the East Coast that were sort of early on, but we've really seen in recent years an explosion in this area of law. Tons of website accessibility cases filed. Now when I get a website case, when I get an ADA case, it's almost 50-50 whether it's about a physical issue or a website issue. So what is website accessibility? It really pertains primarily to people who are blind. If you're blind, then you are going to use software that scans the website page and reads it aloud to you so you can hear it. And so websites, they need to be built and coded so that they are compatible with that screen reading software. And so the actual code of the website needs to be designed so that someone can basically hear the website using that software. So for example, images on a website need to have an alternative text description that basically describes what the image is showing. It doesn't appear to the ordinary user who can see the website. It's really embedded in the actual code of the website, sort of behind the scenes, if you will. So it's not visible to the ordinary user just looking at the site, but it's included in the actual code, in the actual HTML that the website uses. There needs to be sufficient color contrast. So the two boxes on the right here have good color contrast. And so the text, it pops out from the background. You can see it easily. And the ones on the left here have bad color contrast, so they're hard to see. So for people who are low vision, not totally blind, but can see a little bit, there needs to be enough contrast with the background. There are a few other issues related to website accessibility. Like I said, I've done some computer programming and some website design in the past, and so I won't get too much into the details, but there are issues related to providing enough time for someone to read text that's moving and for keyboard navigation. The ADA, you know, it was written and passed in 1990, like I said at the beginning, and it actually never mentions website accessibility, but it does have very broad requirements that courts have interpreted to apply to the websites of businesses. The Department of Justice gets involved and can enforce the ADA. Okay, so here we're talking about website accessibility litigation. Like I said, courts have interpreted the ADA to require website ADA compliance. At first, we saw a lot of complaint letters sent to businesses, and still do, but more and more plaintiffs are just suing businesses for website issues. We see this a lot actually with restaurants and their menus. So, you know, people who are blind want to understand what the menu is showing, and if it's just a PDF document on the website, you know, a PDF is basically an image file, and so it's not screen readable. You can't read the individual menu items and how much they cost. So the Department of Justice is responsible for enforcement of an enactment rather of ADA standards, and they've done this for physical accessibility issues. There are strict rules on how wide a doorway needs to be, on how flat a parking space needs to be. But the Department of Justice has not yet issued similar standards for website accessibility. We're still waiting on that. So in the meantime, what courts generally look to determine if a website is accessible is this, the WCAG, the Web Content Accessibility Guidelines. And these are basically these are standards, they're rules for what a website needs to have to be accessible. And they're published by the World Wide Web Consortium. It's an international organization that helps create standards for the World Wide Web in general. So this is what you're basically shooting for. This is what the website needs to comply with to be considered accessible right now, according to the courts. Here's a look at website accessibility litigation. Like I said, we just see more and more of these types of lawsuits filed. A lot of businesses have websites that are not accessible. We see this a lot actually in businesses that a lot of them have websites, and they might use a software feature like Accessibility or some of these other companies that let me just write a note here. Some of these other companies that will offer to fix your website for a very cheap price, maybe 30, 50 bucks a month, but they really don't do the job completely. Unfortunately, I wish they did. It would be much simpler for businesses just to pay a small amount and have their websites be made accessible. But all the software does really is it takes care of some of the easy fixes, but it doesn't take care of the hard fixes. Software is not enough yet to make sure that a website is accessible. One thing that you still need is you actually need manual testing. So you need an actual person to look at the website and test for whether or not it's compliant. So software can scan the page, and it can tell you whether or not an image has an alternative text description or not, but it can't tell you whether or not that alternative text description is accurate. For that, you still need a person. And so you still need someone to actually make the website accessible by hand and ensure that it's accessible. So one thing I do for my clients is I do some testing on their website. I can do this through software and through manual testing by looking at the code myself. Here's an example of some testing that we've done. There are 46 errors on this page. So on this website, on this web page, there are 46 likely violations of the ADA. And so this is just something to be mindful of. If you need some help with your website, please go ahead and reach out to me. I'm happy to do some work for you. Here's an example of a website accessibility report. We'll prepare these reports for our clients, and it'll have details about the business's website, whether or not it is compliant, whether or not it meets the WCAG standards, and what you can do to fix it. One of the last things I'll mention here is that we've been seeing a lot of these cases for videos on websites. If you have any video on your website, it needs to have closed captioning. So those are the words that appear on the video as it's going to explain what someone is saying. So you need to have the wording, the closed captioning available. There's one plaintiff in particular. His name is Thomas DeRobiala, and he basically just goes around looking for websites of businesses that don't have closed captioning on the video. So you want to be mindful of that and try to take care of that before you get a lawsuit. The last thing I'll mention is that there's been a growing area of mobile app accessibility. So if you do have a mobile app on that you make available to people, just make sure that that is accessible, that it complies with the ADA as well. This is the website that we use. Oops, sorry about that. This is the website that we use to publish information, news and articles, questions that people have about the ADA. I'll publish an article on this blog here, and it might answer some of the questions or provide information about how to defend these cases, how to avoid these cases. So feel free to go here to this website and take a look at the articles we have. You can subscribe by entering your email address and receive emails when we publish a new article. That's about it for me. Here's my contact information. Go ahead and take a picture or write this down if you like, and reach out if you have questions about the ADA, or if you need someone to represent you if you get sued in a lawsuit. And I'd be happy to help. All right, so I'll stop the screen sharing now. Go back to the main portion.
Thank you, Stuart. There is a question in the chat that I think we can go that we can do before Regina sets up her presentation. We will have some information about the resources for San Francisco businesses. And I will be sending some more information about resources through the chat for other businesses. So the question is, when they sue the company because of the website, what will be the punishment, or how to resolve the case?
Yeah, sure. So when someone brings a lawsuit against your business for a website violation, what they're suing for, the remedies as it's called, is basically the same as for a physical accessibility case about parking or a restroom. The first thing is they're suing for injunctive relief. So they're suing for a court order to make the website accessible. The second thing is they are suing for their attorney's fees that they have incurred by bringing the lawsuit. And usually that's somewhere around $10,000, maybe $15,000. It can go a lot higher if the case goes, all the way through motions and through trial. And so the third thing they're suing for is statutory damages under the UNRRA Civil Rights Act, and that's the $4,000 per visit, essentially. And so, it can get expensive quickly. You definitely want to make sure that, you try to avoid one of these lawsuits if possible, and that you hire good defense counsel if you have been sued.
Thank you, Stuart. Regina, did you want me to share my screen with the presentation? Or you can do it on your end too?
Let me try. I'll try.
Okay, sounds good.
All right.
Meanwhile, you're setting that up, I did want to share that one of the things that we are that we support with at Legal Services for Entrepreneurs is that we can review commercial leases and kind of let you know, help you sort of negotiate those leases to be able to see if we can make sure that you wouldn't be responsible for the to be in ADA compliance. It would be like on behalf of your landlord, and so we would try to help you with that. And so I will be sending information through the chat about our virtual legal clinic for folks that are in California and are able to attend. We'll have it on November 2nd. It's free. It's a one hour consultation with our volunteer attorneys. And if you have any questions on ADA, feel free to bring those to that. And then go ahead, Regina. Thank you so much for providing this information.
Yes, and thank you for the invitation. So Michelle Reynolds, who is also the other grant administrator for the Accessible Barrier Removal Grant through the Office of Small Business, she's not able to join us today. I'm going to cover a grant program that the city is providing to help businesses pay for remediation of barriers in the built environment, so not the website. All right, why is this not? Our framing in the Office of Small Business is that, we're government. So, and as city government, we really champion the civil rights of all people. And so that includes the civil rights of individuals with disabilities. And therefore, we as a government have an obligation to be supporting individuals with disabilities and you as businesses in upholding these civil rights. It's a complicated process, as you have learned through Stuart's presentation. It's not necessarily completely cut and dry in terms of, you know, when you're opening a business and doing tenant improvements, the building code is intended to help support it, but it doesn't support it necessarily all the way. So this grant program, it helps to pay for remediation of barriers, including the Accessible Business Entrance Program. And the Accessible Business Entrance Program is a local program that is really targeted to the property owners to remediate barriers in the entryway. This program is running through the end of the year of 2025. Property owners need to remediate barriers by the end of 2025. The unfortunate thing is because of state law, we cannot prevent the property owner from passing on that obligation to you, either through completing the program for them, or they will remediate the barriers and pass on the cost to you. So any cost a small business incurs having to comply with the Accessible Business Entrance Program because their property owner is requiring them to do so is covered in this grant program. And during this, we also help provide guidance, you know, in terms of the best way to approach remediating barriers, whether you're a new business or an existing business, along with the financial support that's there to help you. And then through our permitting staff at the Permit Center, we also have support for you in navigating all the different city agents.
So sorry to interrupt. Yeah, you are breaking up a tiny bit, so I don't know if it would help to turn off your video. Maybe it will help the stream be easier.
Okay, just one sec. Oops, that's not what I wanted to do. Sorry, folks. It's not letting me turn off my video. Oh, there we go. All right. So this is a grant program. Businesses are, I'm just going to go back. I guess this is a grant program that allows businesses to receive up to $10,000 in reimbursable expenses. So an eligible business is a business that's registered in San Francisco, can be a nonprofit, but needs to be current with the state's Registry of Charitable Trust, not have a gross revenue of more than 2.5 million if you're a single location business, or if you're a business with multiple locations, you can have revenue up to 8 million, have under 100 employees, and be a place of public accommodation. So, and Stuart went over that definition, and I have a definition also at the end of the slide. And here is where the grant, here's a web link of where the grant is on the Office of Small Business website. Okay. I am just having a lot of problems today. Okay, yes, this is what I'm going to do. Oh, another thing that I do want to also highlight is that we do our best to partner with other grant programs within the city to help maximize the funding that's there to support you in remediating the barriers. So what is a reimbursable expense? So reimbursable expenses are invoices for paying for a certified access specialist to do a full inspection and provide you with a report of your business. This is something that we encourage particularly all existing businesses to do, so that you can have those barriers, if there are any, be identified, and what needs to be done to remediate them. If your property owner is requiring you to comply with the Accessible Business Entrance Program, then we pay for the category checklist. And that can be done by a certified CASP, certified or a licensed architecture or engineer. Will reimburse from invoices from those entities to complete the category checklist. And then whether it's from your remediating barriers from your CASP or from the ABE, which is the short for the Accessible Business Entrance Program, then we will cover architectural design services for ADA barrier removal, and engineering design services for ADA sidewalk remediation. And for architectural design service for the ADA barrier removal, if you are a new business moving in, and so you have multiple tenant improvements you are doing, but you are putting in an ADA bathroom, or you're moving some walls to widen a door, something along that lines, then we encourage you, for us to be able to remediate for the ADA portion of the services, to ask your architect to isolate those and itemize them separately on the invoice. We will also cover construction and labor costs to remove ADA barriers, but this must be done with prevailing wage, and I'll go into that a little bit later. And then any relevant permit fees, as long as the work is done with prevailing wages. And then we will also cover ADA compliant equipment, fixed furniture, fixed fixtures, and or materials. So with a CASP inspection and report, an accessible business entrance category checklist, this is kind of the first step that is required for this program.
Sorry, Virginia, I think
you will reimburse invoices that you pay directly to the certified CASP licensed architecture engineer, or if your property,
I'm not sure if I caught that piece. It's breaking up quite a bit for me.
Is it?
Yes.
Okay.
Just I think that's the most recent slide.
Okay. So for CASP inspection and reports, invoices to be, will reimburse for accessible business, paying for accessible business entrance category checklist, whether you pay the individual directly who's doing the checklist, or you reimburse your property owner. And if you're reimbursing a property owner, they need to provide you with the invoice, and then you need to submit proof of payment that you've paid them for that invoice. And then for the certified access specialist, for the full inspection and report, we reimburse for those invoices, but we do not reimburse for hourly consultation or services related to lawsuits. In regards to types of equipment that we will reimburse for, many of our grant applications, they unfortunately are being required by the property owner to complete the ABE. So many of the invoices that we're reimbursing for were power door operators, along with the push button and panels. But other equipment could be hearing interpretive devices to help you communicate with businesses. And if equipment rental is required for, like, jacking up the sidewalk, because you're leveling the sidewalk and doing sidewalk repairs, that type of equipment is eligible as well. Fixtures are items that are fixed to the wall, the floor, or the entryway So doors, door frames, handrails, bathroom bars, and so on. And then furniture, only non-movable furniture is potentially reimbursable. That would be bar counters or sales counters that you're having to purchase to include the ADA service section. And then materials, the types of materials can be concrete, framing materials, replacement tiles. Often that happens in the entryways. And if any paint, it's kind of an example of, the area around having to reframe a door, put in a new door with the power door requires painting. For labor to be reimbursed, this requires contractors to confirm that they pay their employees and subcontractors a prevailing wage. And prevailing wages are more union rate wages, so smaller contractors often don't provide this. So if you are going to be engaging in any barrier removal, this is something that I would ask your contractor ahead of time if you need to have as much of your remediation cost covered. To provide proof of prevailing wage, we need the contractor to provide a written attestation from the contractor and also have it noted on the final invoice. And there's a website that you can provide your contractor for them to review if they're not sure. And again, as I noted earlier, permit fees reimbursed will be reimbursed when we receive the contractor's attestation of prevailing wage. And OSB, we do have a list of power door installers that do meet the prevailing wage requirements. So if that is something that you are going to need to do, you can reach out to us and we can provide you that list. Reimbursement for architectural services. Services are needed. Architectural services are needed to complete the ABE process. So again, if your property owner is requiring you to do that, that's one reimbursable expense. Then also, you might need construction or architectural services if you're opening up a new business or it's construction related, like through a recommendation from a CASP inspection. And as noted, that if there's more services that the architect is providing for beyond the accessible, more than just accessible area, then they need to identify their work, their hours that were specifically related just to ADA. Architectural services, architectural services do not require a prevailing wage attestation. So reimbursable invoices are invoices that are paid after July 1, 2019, and you'll need to provide proof of payment along with it. It's best to have the invoices itemized separately, materials and labor cost, labor and installation cost. And if there is labor and installation cost, it helps us to more quickly approve invoices if the number of hours of labor and installation hours are included. Again, older invoices, it may be harder to go back through. I would still submit them and we'll look at them and figure out how best we can figure out, if the labor isn't at prevailing wage rate, what we can reimburse you for. ABE inspection invoices should specifically state ABE checklist. And that's so that if later on you want to get reimbursed for a full CASP inspection, then we can reimburse you for a full CASP inspection, because often CASPs are also doing ABE inspections. And so again, you can't submit twice for the same services. but an ABE inspection and a full CASP inspection are two separate things. And then submit the final paid invoice. You need to submit the final paid invoice or invoices for proof of payment. Invoices can be submitted on a rolling basis. So again, you know, if you paid for the CASP inspection and then architectural services, you can submit those before you start doing your remediation barrier. And then quotes, you can, will accept quotes that are no more than 6 months prior to the submission date. And you're certainly welcome to submit them to have us take a look and get input as to their eligibility. Excuse me, sorry. In addition to the grants, there are annual federal tax credits and deductions. So again, if the grant is not able to fully reimburse you for your barrier removal cost, then you can utilize the annual federal tax credits and deductions to offset the costs not covered by the grant. If you plan things out well, you can plan, tax credits, grants, and then maybe tax credits to complete the project the next year. And if any of you are in need of having the information about the tax credits in other languages, we do have it translated in Chinese, Spanish, Filipino, Japanese, Russian, and Vietnamese. We kind of took a look at what are popular populations for restaurant owners. And then I and Michelle Reynolds are the grant administrators. Our role is to really help you, utilize this grant to the best of your ability to remediate barriers. We want to see this. We hope that this is an incentive to you to remediate barriers in your business or in your business. And we'll take questions later. With the slides there, I have also a list of places of public accommodation. I've also included resources. So the Pacific ADA Center. So let's say you are a business that's going to be on the 2nd or 3rd floor, and there's no elevator in the building. Then we recommend you call them for advice on how to communicate with the public on how to provide access to sort of equivalent access to goods and services, since not everyone will be able to get to your business. If you need any assistance of understanding what might be readily achievable, both the Pacific ADA and the Department of Justice. So these are some resources that we often refer businesses to, because we may not, as government, we can't provide certain sort of specific guidelines, but resources on who you should talk to help you figure out what you need to do to ensure you're compliant. And I realized I forgot to put in the slide with the Office of Small Businesses website and contact information. So Anna, I'll send you an updated slide. I'm going to stop sharing because I'm done. Updated slide deck that you can send to the participants.
Okay, thank you, Regina. Thank you so much for the information for our San Francisco small businesses. I know there are other folks probably that are not in San Francisco, but there might be resources in your city. So I think it might help to talk to someone that would be able to help you in your city. There is a question. Oh yeah, and then Regina, I think you're typing it, but maybe Stuart also has some advice. How can I get my flower shop inspected to see how compliant it is?
Yeah, I can answer that. Regina mentioned there are what's called CASP inspectors, and it stands for Certified Access Specialist. And it's generally either a former architect or engineer who's been certified to review properties and look at them for ADA compliance. And I'm happy to provide some names and recommendations if you email me. And they'll go out to the property, they'll take a look and figure out what is accessible, what's not, what complies with the ADA, what doesn't, and they'll provide a report showing what improvements need to be made to the property. Generally costs somewhere around $1,000 to $2,000, give or take, depends on the size of the property, but something in that general range is usual, and it can be very helpful. So I would recommend it.
Anna, I decided that I'll just answer, and I'll provide this in the slide deck.
Okay.
Yes, so the Office of Small Business also has a list of CASP inspectors that we've contacted and said that they'll work with small businesses as well. So Stuart may have some of the same individuals. So we have that as a resource as well. And again, if you are in San Francisco as a business and you do get the CASP inspection, then you are eligible to get that reimbursed.
Thank you so much to you both for that information. I just want to share that if you have any commercial lease issues or ADA issues, are currently in an ADA lawsuit, please feel free to reach out to Legal Services for Entrepreneurs program. If you are a low to moderate income business in the San Francisco Bay Area, we can figure out and see if we can help you. And then I think we can also refer folks to Regina's office and see if Stuart will be on board with maybe some pro bono work. So we thank you so much to both of you for all of your information. I think it was really helpful to hear about the different types of ADA that we need to consider with small businesses. Was there anything else either one of you wanted to share out?
Nothing from me.
I think that that's good, and we work closely with Legal Services for Entrepreneurs, the Office of Small Business, to help you. So we also do referrals back and forth and helping you with your leases.
Well, thank you so much. And thank you so much for everyone attending. We'll send out the recording of this webinar by the end of the week, and you'll be able to access that information, and as well as the slides that Regina and Stuart presented. But thank you so much for everybody, and I'll go ahead and end the webinar now.